May it please the court, George Rares on behalf of Mr. Hojan. The issue in this case is a death sentence recently returned in Broward County based on a 12-0 recommendation of death. The issue that I'd like to speak to this morning is the jury selection issue, which kind of led to an anomaly in this case. Mr. Hojan, originally under a different set of rules in Florida, different burdens of proof, different jury instructions on the issues, had three individuals that felt the life sentence was appropriate. Upon the remand for strictly a penalty phase, all 12 jurors recommended death. And I think the record is clear that the restriction that the court placed on the voir dire process of the defense counsel was the reason that a true cross-section of the community that would look at this fairly and impartially, there were no individuals on that jury that felt a life recommendation was sufficient under the circumstances of this case. The issue deals with hypothetical questions. Defense counsel in this case had been trained in use of a method of using a hypothetical question, a single question, posed to all of the jurors that would not repeat any facts or circumstances of the particular case at bar, but would allow jurors to give their impression and to talk about how they felt about mitigation, potential mitigating circumstances in light of the aggravation that the state expected to prove and that the defense recognized the state would likely be able to prove, particularly because the case had already been to bar at one point in the past.
Counsel, can I interrupt you for a second? So
Yes,
this hypothetical is on pages 15 and 16 of your brief.
Yes.
So when you get down, you have all the sort of prefatory stuff, but then when you get down to the kind of money sentence, it doesn't even make any sense to me. If I were a juror, a prospective juror, I wouldn't even know what the question was asking me. When it says, what are your feelings about the death penalty as the only appropriate penalty for the guilty, for that guilty murderer? I mean, is that an assertion that that is the only appropriate penalty? Is that asking me if it's the only appropriate penalty? I mean, it seems like you're asking us to say that it was harmful error not to have allowed the asking of a question that on its face is kind of incoherent.
Well, I don't think that particular portion was drafted particularly artfully by defense counsel. I think that question itself was the beginning of the questions that he would inquire regarding the fact pattern that he was going to give as a hypothetical. I think that the state's brief on the matter and the way that the court interpreted what defense counsel was trying to do exposes the problem. In the brief presented, it indicates that the defense counsel was trying to pose a hypothetical question using unrelated fact pattern during jury selection for the purpose of uncovering potential juror bias or automatic death sentiment. I don't think that was the purpose at all. He was attempting to rank the jurors that had already passed the judge's questioning regarding automatic death sentiments or bias and the state attorney's questioning regarding that, and be able to rank them in terms of whether or not a peremptory challenge should intelligently be used against a particular juror. That's the purpose of the jury selection method that this attorney had been recently taught and what he was trying to accomplish in that process of voir dire. Based on the court's answer to that attempted hypothetical, which was basically you must stick to the three wit questions, which is really just reiterating what had just been done by the judge and the state, he was not allowed to go outside the confines of those three wit questions. Defense counsel is trained that there are two roles at that point in the process. One, of course, is to help to identify automatic death or jurors that would never impose the death sentence and remove them for cause. But I would suggest in a case like this, the even more important question is, how can defense counsel ask questions that will help him to intelligently exercise the peremptory challenges that the law gives him? And he was unable to do that in this particular case based on the restriction placed by the court. The brief from the state talks about the fact that, well, he did go beyond the confines of wit a couple of times, even against what the court was ordering him to do, and that it's okay because he did that. He was able to get other questions in. And I would suggest with the gravity of the death penalty to restrict defense counsel from a basic hypothetical which would allow him, which is a tested method, a method that's taught across the board in the state of Florida and around the nation in how to help attorneys to intelligently exercise the peremptories, was an abuse of judicial discretion under the facts of this case. I would also point out,
Mr. Reyes, just one quick question.
Yes, Justice Lamar.
Did the judge in this particular case prohibit all hypotheticals or just that one?
He appeared to say that there would be no hypotheticals and that all questions should stick to the 3 wit questions. Now, the attorney attempted to get some hypothetical questions answered, but from the time that he was restricted from asking the single hypothetical to each juror the same way to be able to rank their responses to that question, he was thwarted. And as has already been pointed out, the record was not as clear as it should have been on what exactly he was trying to do and how he was trying to do it. But I think from the record, we can see that this particular judge had decided that the method of jury selection that was going to be employed in this case, he had actually given a continuance to allow the attorney a chance to go to the seminar to be counseled in this method, was not going to be allowed in his courtroom, and he wanted to test that. In fact, and the record reflects, he said, if you don't like my ruling, take it to the Supreme Court.
Have you yourself used this method before in trying other cases? You're a seasoned lawyer.
I have not. I've used other methods over the many years. I've tried 30 first-degree murder cases, 13 with the state seeking death. This is all new to me. When I was a public defender for 30 years, I tried the majority of those cases. Now in private practice, I'm doing other things, as well as still handling death penalty cases. But for the court to really blow the attorney out of the water at the beginning of his voir dire process by telling them, no, you can't ask hypotheticals, and no, you can't use this method, you must stick to the 3 wit questions, really prevented him from having any rational system of measuring these jurors' responses to how they might receive the mitigation that in this case they knew was going to be presented. The facts here are Mr. Hojan refused to allow any mitigation presentation in his original trial, and still 3 jurors under the fact pattern presented recommended life sentences. Here, where he did allow mitigation, and there was some mitigation presented that I think was compelling in some ways, was able to get no jurors, was a reflection of the judge unfairly limiting defense counsel and beyond judicial discretion, particularly in a case of this gravity, where the state had wide discretion in asking questions prior to defense counsel getting up, where the judge had asked his own questions, all geared largely towards identifying cause jurors. The other unique fact here I think is important for the court to consider is, in the process of normally selecting a jury, many of the questions that deal with burdens of proof, presumptions, the law itself relating to the charges, gives attorneys an opportunity to observe the jurors answering questions on a broad context that helps to form opinions about which jurors would be more or less likely to impose the death sentence. None of that was present here because it was a resentencing only for the issue of life or death. And that handcuffed the attorney as well. Without any of those observations, this particular method of jury selection, if allowed, would have given him at least an opportunity to get the jurors talking about those issues, mitigation versus aggravation, to get some idea of which jurors he might intelligently strike and others he might feel he would like to leave on the jury on the issue of what the ultimate sentence they recommended would be. And I think under the totality of facts here, it was an abuse of discretion for the court to test his theory that these questions shouldn't be allowed at all, and that it could be sustained on appeal if he denied them, all the way to the Florida Supreme Court. It was one of the last trials, if not the last trial, this judge did before retirement. And it's clear from the record that the attorneys for the defense were kind of ambushed by this decision, that they weren't going to be allowed to ask this type of question, when in fact it was the way they had prepared the voir dire, and they scrambled to try to do the best job they could, but I think it fell well short. And I think the evidence of that is the same fact pattern under better law, under the jury being instructed, the state now has to prove certain things beyond a reasonable doubt that they didn't previously, results in a 12-0 death recommendation. Again, judicial discretion is wide in voir dire, and for good reason, because every case is different. All the facts are different, circumstances are different, and it's impossible to state exactly what questions should be allowed and shouldn't be allowed that would go across the board and cover all facts and circumstances, all types of cases. So judges need to use their discretion to allow the defense, particularly in a case where they have no opportunity to voir dire on the issues of whether or not a juror can sit in judgment of the facts and circumstances, in a case where the only thing that they're going to be judging is literally life or death. And under the facts here, and I think the record is pretty clear, that this was an abuse of discretion by the court. It was unnecessary. The questioning defense was trying to do would not have taken any longer than the questioning that was actually conducted. In fact, it probably would have been much quicker. It would have been far more to the point if the attorney had been allowed to go forward and actually pose the questions. Some of the issues that have been pointed out would have been cleared up by the nature of the question and the answers in response. And under the facts and circumstances, again, with the gravity of this case, I would ask the court to rule that he's entitled to another penalty phase where the attorney can pursue voir dire in terms of not just whether jurors are qualified to serve, would they automatically vote death or automatically vote life, but how do they feel about the issues of mitigation versus the issues of aggravation that would be presented, not to prejudge the issue. The state's brief also points out that they feel the defense was trying to get the jurors to pre-commit to a particular position. The judge mentioned that at the trial, as did the state attorney. And that is not the intent of this method of jury selection at all. That's clearly improper. It's a method that allows the jurors all to talk about how they feel in light of a particularly heinous fact pattern. Would mitigation even be considered by them based on the most horrific case, which was the pattern of the hypothetical that the defense attorney was trying to give? Would it matter to you at all if he was abused as a child, if in fact the state was able to prove A, B, C, or D in terms of aggravation? And then how do they respond to those questions is the only real basis that the attorneys would have to determine whether to exercise a peremptory on this particular juror or that particular. And I would reserve the rest of my my argument time for rebuttal, if I might.
Right. Counsel?
May it please the court. Lisa Marie Lerner with the Attorney General's Office for the state. Your Honor, the court here did not hamstring the defense in any way during the voir dire process. The court restricted counsel from asking a specific type of hypothetical question. The type of hypothetical question where counsel presented a fact pattern to the potential jurors, the veneer men, and asked them to prejudge how they would vote given a certain factual pattern that he was suggesting. And the harm that the court was preventing by denying counsel this opportunity to do the hypothetical was that no matter what answer the juror would give, the juror would have been engaging in prejudging a fact pattern and weighing certain facts as having more value than other facts. That is the harm that these commitment questions cause, that the judge rightly did not abuse his discretion in preventing from happening. And although Florida does not have a long case law on this type of question, other states do, and they routinely prevent counsel from using this method and going into factual hypothetical questions which ask for a commitment one way or the other from a potential juror member, because it's the type of question itself that creates a bias or a prejudice within the juror for what they will hear when the actual evidence comes in. And so it was only that type of question this court prevented. Defense counsel completely had access to all other areas of voir dire. His voir dire covered a couple hundred pages of transcript. He went into mitigation and aggravation at great length and got the individual jurors to talk, which is what was his stated purpose was to the court at sidebar. And he had long discussions with a number of the veneer people about their attitudes on mitigation and aggravation. In fact, I referenced one particular juror on, I believe, page 12 and 13 of my answer brief, where the juror actually said something along the lines of, well, if you had asked me at the beginning of this process of voir dire, I may have given you a different answer. But now I understand the importance of mitigation, and I understand the importance of someone's background in assessing what recommendation we are to give. If that's not evidence that the defense counsel successfully educated these jurors on the importance and the nature of mitigation and what is mitigation, I don't know that you could get a more blatant example of a juror absorbing and utilizing that information. And the defense counsel did ask somewhat hypothetical questions about premeditation, spent tens of pages on the concept of premeditation and whether or not it would trump mitigation. And he educated the jurors on that area as well. Counsel in his brief had mentioned that he was concerned that defense counsel couldn't get into the questions of whether life was always an option. He did. He spent a long period of time questioning the jurors and getting them to acknowledge that no matter how much aggravation is presented, life is always an option for them to vote on. It's never an automatic death sentence, no matter what the state presents. And so if the court looks at the entire voir dire record, the defense counsel was not stymied and he was not ambushed by the court, preventing him from going into this one type of hypothetical question. And if the court has no further questions, the state asks that the judgment and sentence be affirmed.
Thank you. Counselor?
Thank you. I think it's pretty clear at this stage that hypothetical questions should be permitted, particularly in a death penalty case. In this case, I don't think the court wanted to allow any hypothetical questions. I mean, the court's ruling was stick within the three corners of the wit questions, the four corners of the three wit questions. The fact that the counsel for the state points out that defense counsel tried to get around that, that's not the way to pick a jury in a death penalty case, trying to get around the ruling of the court, which is erroneous. The court's ruling to stick within the wit questions was clearly wrong. He should not have hamstrung defense counsel in that fashion. And the fact that that counsel went left, went right, tried to go over and around that obstacle does not remove the fact that in a case of this gravity, the court should have, within its judicial discretion, allowed the defense an opportunity to be able to ask questions that would rank these jurors in terms of their likelihood recommending death versus the likelihood of a life sentence recommendation.
Counsel, I'm sorry to interrupt you. Could you be a little more specific about, it's not clear to me what exactly sort of the rule of law that you would want to come out of this case to be, in the sense that it seems like if the question is, is it reversible error not to allow these specific proffered questions? I think that would be kind of absurd. if you're asking for something sort of more general, that it was error not to allow counsel to do X, Y, or Z, I'm trying to understand what is that? Because I mean, it sounds like, you know, looking at the record and given the arguments that the counsel on the other side made, it's not as if there wasn't an ability to explore some of these obviously very important issues. I'm trying to understand how we would articulate what the error was.
Well, I think and again, judicial discretion should be wide. And the reason it should be wide is every case is different. Every case has certain circumstances that need to be dealt with in the voir dire process. But particularly in a case, if I could proffer what the rule of law should be, it should be that when the defense counsel is picking a jury only for the issue of life or death, that there needs to be more discretion afforded that counsel than there would be in a case where you begin your voir dire process with talking about the general qualifications to serve, what the legal process is about. Those observations that are made at that stage of the trial are crucial, and they carry over into the final decision as to which jurors should be preemptorily challenged. To say that the state can go forward and the judge can go forward on the Witt issue and weed these people out, but that the defense, under the circumstances, without any other opportunity to even observe them answering the standard questions of a normal voir dire for guilt or innocence, could be restricted to the Witt questions, I think was an abuse of discretion under the circumstances. It was not articulated well by defense counsel. Granted, the question he proffered into the record does not accurately, in my opinion, state what the method of jury selection that he's trying to use really is and how it should be used. But that would have cleared itself up as if he had been allowed to begin the process and proffer the hypothetical. He was shut down before he could even put that hypothetical out in front of the jurors at the sidebar conferences that resulted from the objections.
And then let me just, while you're paused, in a related question. So assuming that the rule that would come out, the rule that you want, is that it's error not to allow hypothetical questions on this topic in a sentencing phase proceeding, how would you show harmful error when the trial judge allowed questioning on the topic and it appears from the record that he was able to fully explore the topic in a different manner?
I think the way you see that it's reversible error here is you look at the first trial and you look at the fact with no mitigation presented whatsoever, the same circumstances, same facts, 3 jurors feel that that's a fact pattern. There was some merit to a life sentence.
Is there any support for that in the law? The fact that you didn't get the result that you wanted? That's not the way generally in these kind of cases, if the test is whether the record reflects that the trial court barred counsel from sufficiently covering a topic that was important to the trial with potential jurors so that he could not uncover bias. And if it appears that he could uncover any bias given the latitude that was given, then I'm not aware of any case or principle of law that would allow you to say, well, we lost, so you just should assume that it's harmful.
Well, the focus on bias, again, was what the trial judge was focusing on. I think the responsibility of defense counsel, particularly in light of the changes in law that have occurred in the state of Florida, is to be as careful in exercising peremptory challenges as they are in making sure that a biased juror, one way or the other, doesn't get on the panel. Particularly in an era where when we do death qualify jurors, something in the area of 4 to 1 of the jurors that are excused for bias are life favorable jurors who are not able to get on the jury because of strong moral and ethical conviction against the death penalty. And then to remove all of those jurors, and along with the smaller number that perhaps would say, no, if someone is convicted of murder 1, I think death would always be appropriate. And then to restrict the ability of counsel with no process to ask normal voir dire questions, no opportunity to observe them answering those questions, to say stick within the 4 corners of the Witt doctrine, just 3 questions, and be looking only for bias, excludable bias, or cause challenges, ignores the fact that our obligation as defense counsel is to intelligently exercise peremptories as well. The law provides those peremptories, and to eliminate the ability of the defense counsel to ask the questions that would allow some measure of ranking of the jurors on that issue. Under these circumstances, perhaps this unique fact pattern, I submit to the court was an abuse of judicial discretion. There was no need for it. And under the circumstances, an abundance of caution, 3 jurors had already recommended life. I would suggest that Mr. Hojan get a new penalty phase where his attorneys can make intelligent use of those peremptory challenges. Thank you.
Well, we thank you. We thank opposing counsel for your arguments. And that is the last case on today's docket. So the court will now stand in recess until tomorrow.